The Rules Committee will come to order. We don't have a quorum present, but Mr. McGovern has very generously indicated that we can begin with the hearing process. We're getting close to a quorum. We are here for consideration of the Workforce Democracy and Fairness Act, H.R. 3094, and we're happy to welcome 4 members of the Committee on Education and the Workforce. And we'll begin with the chairman of the committee, my good friend Colonel Klein, and without objection, any prepared statement that any of you have will appear in the record in its entirety, and we welcome your summary. So please proceed, Chairman Klein.
Thank you, Chairman Dreyer, Ranking Member Slaughter, members of the committee, for the invitation to appear
today. Say for the record that we have a quorum present at this point. A super quorum now that Mr. Scott's walked into the room.
Thank you, Mr. Chairman. I'm taking advantage of your kind offer to include my entire statement, which is only slightly longer than the proposed legislation. I will submit that for the record and take a couple of pages to summarize the bill. The Workforce Democracy and Fairness Act reflects our commitment to protect the nation's workforce and is an inappropriate and necessary response to actions taken by the National Labor Relations Board. Let me just sort of recap where we are. Under current policies, union elections are held an average of just 31 days from the filing of a petition. Employers can effectively navigate all the complexities of federal law. Workers have the time they need to be fully informed, and unions prevail in almost 70% of elections. In fact, Acting General Counsel Leif Solomon, Acting General Counsel of the NLRB, called the board's handling of union elections outstanding. So what's happened? Under a recent NLRB proposal, employers will have just 7 days to find legal representation, prepare their case, and workers may have as little as 10 days to decide whether they want to join a union. The board has recently abandoned nearly 30 years of board precedent in its specialty health care ruling in order to empower unions to manipulate the workplace, resulting in higher labor costs for employers and less workplace freedom for employees. So, H.R. 3094 simply sets in law a successful election process that has been around for decades. The bill preserves workers' free choice by giving them a reasonable opportunity to make an informed decision. It protects employers' free speech and their ability to participate in a fair election process by giving them a minimum of 14 days to find legal counsel and prepare their case. In summary, the legislation reaffirms an election process that has long protected the rights of workers, employers, and unions for decades. Unfortunately, there have been a number of false statements to justify opposition. Among the myths, one of them is this legislation prevents union elections. No, it doesn't. H.R. 3094 states an election is to take place as soon as practicable, but no earlier than 35 days to give employees time to make an informed decision. There's a myth that says the bill encourages frivolous delays. Not true. Employers and unions are free under the bill to raise relevant and material concerns throughout the pre-election hearing. In short, we believe that this bill is a measured response to the board's activist decisions. It restores important protections that our nation's workforce has long enjoyed, and I urge members of the committee to support a structured rule and the underlying legislation, and I yield back.
Thank you, Chairman Dreyer, Ranking Member Slaughter, and the members of the committee. Thank you for having our committee testify. I must begin by saying that I'm disappointed that we're meeting yet on another attempt to take away the right of our American workers. At a time when 14 million Americans are actively looking for a job, and there's clearly more important things that we can be doing other than continuing the majority's obsession with dismantling workers' unions. Today's debate stands in stark contrast to the message the American people are sending to their elected officials all across the country. It's time to drop these special interest crusades and begin to work together to tackle our nation's real problems. That's the message the Ohio voters sent last week when they overwhelmingly rejected a special interest ploy to strip Ohio workers of their collective bargaining rights. I had hoped that this message would have been heard inside of the Beltway. Unfortunately, today's debate tells me otherwise. Let's be clear, passing H.R. 3094 will not create one job to support one family, nor will it help a worthy small business gain access to credit they need to expand, nor will this bill do anything to rein in China's currency manipulation. H.R. 3094's singular goal, however, is to frustrate workers' rights to vote. It's as simple as that. More accurately called the Election Prevention Act, this bill will be used by unscrupulous employers to delay elections by months or years. It encourages frivolous litigation to gum up the election process and to frustrate workers until they give up on having any election at all. The Election Prevention Act also gives employers the ability to gerrymander elections. It does this by stuffing the voter list with voters who have never engaged in an organizing drive or never expressed interest in joining a union. This gives employers an edge in preventing an election from ever being directed in the first place. It is clear that H.R. 3094 is just another cynical attempt to bust workers' unions. We all have seen the majority push through a bill to strip the only effective remedy that the NLRB's arsenal to deal with unlawful outsourcing. And we've seen what happens to the NLRB simply tries to enforce the law. Opponents come out, guns fully ablazing, against the agency. Mr. Chairman, these attacks on workers' rights promise to inflict long-term damage on our economy. The exercise of these rights has helped create a strong middle class, and the piece-by-piece dismantlement of these rights will do just the opposite. Our nation's economic strength depends upon whether American workers get a fair shake, because when they are fairly rewarded, they also create jobs, they support local businesses, they rebuild the middle class, and that's the key to real and lasting economic recovery and economic growth. I ask the Rules Committee to provide for an open rule for consideration on this bill, and I urge my colleagues to oppose this deeply flawed legislation when it comes to the floor. Thank you.
I have no opening statement, Mr. Chairman.
Mr. Chairman, I am prepared to offer an amendment, and I hope the Rules Committee will place that amendment in order. What my amendment does, very simply, is it attempts to defer frivolous filing. It would give the NLRB the authority to impose sanctions on a party for presenting a frivolous or vexatious filing during the pre-hearing stage, the pre-election stage of any proceeding. Attorneys would have the duty to ensure that any filing is not presented for delay, has the basis in law, has the basis in fact, and the denials of the facts are warranted. This amendment is essentially rooted in Rule 11 of the Federal Rules of Civil Procedure, which sanctions frivolous filings in federal courts. There is no current, Rule 11 is not a component of NLRB proceedings, and according to the testimony of one of the former chairs of the NLRB, there is no remedy in for sanction within the purview of the NLRB to deal with frivolous filings. Since the underlying legislation absolutely encourages the filings of various motions so as to delay an election, I think having some measure that would deter frivolous filings makes good sense.
Well, thank you very much to all of you, and you've made your positions very clear. I want to do everything we possibly can. I want to encourage this committee to make in order the germane amendments that were submitted in a timely fashion to the Rules Committee, and I think, based on my first look here, Mr. Bishop, that your amendment falls within that, and so I think that no guarantees, but at this juncture I'm thinking of encouraging the committee to make in order your amendment that would allow it to be considered on the floor. I have no questions other than to say how much we appreciate the hard work, and I think that this is a very, very important measure. Mr. Sessions.
Mr. Chairman, thank you very much. I want to thank each of you for being here today. I, too, am concerned about the ability to have a marketplace that works fairly and openly, and Chairman Klein, I'm very proud of what you're doing today.
Ms. Slaughter.
Thank you, Mr. Chairman. I thank all of you for being here. I do have a question for Chairman Klein. You said that what we're going through now, the certified nursing assistants in nursing home, you said that it was wreaking havoc on the economy. Can you give me an example of a single job that's been lost because of the specialty decision?
The specialty decision itself, having to do strictly with those employees in that union, is not directly affected by this legislation. It is our belief that that ruling, the specialty ruling, will apply to industries all across the country. and that is causing a great deal of uncertainty and anxiety. It lowers confidence on the part of employers. They are less willing to step forward and take risks and hire people, and so I believe that it is unsettling
Before
to
the
the
fact,
economy.
I mean, you don't have any examples that has, that's in the future.
That's
You
correct.
think that might happen?
That's correct.
Mr. Miller, what effect would this bill have on the middle class?
Well, I think that this bill, given the history of the law firms that deal with these issues during drives for collective bargaining rights and to form a union, I think, in fact, this bill means that those elections for collective bargaining will probably really never take place, because this bill not only encourages great delay, but it defines the law in such a fashion. I think that's the concern of Mr. Bishop's amendment, that you can file frivolous action after frivolous action. And Mr. Klein likes to say that it's a very short period of time when elections are held under the ordinary course of business, but he puts into that all of the cases where there's consent between the employer and the employee, which is the overwhelming number of cases, whether the employer, if they have a union, they get their 30%, the employer says, fine, you get the union. But where we do have a contest, that 30 days average, what have you, that immediately goes up to 124 days. It gets to 200 days rather quickly. It averages around 500 days. We, in fact, have had cases have gone as long as 2,000 days. And what happens in that time? That's all the time where the employer continues the campaign in the workplace, on the job site, in the presence of other workers, telling you that if you join a union, the following bad things could happen to you. You could lose your job, to send the work to China. They fire people. It's illegal, but they fire them because they know there's very little to pay if you do it wrongfully under the law. As an example of people who want to join the union, and that campaign continues throughout those 2,000 days, those 200 days, those 500 days, or those 30 days. And so I think you see, and now if you can compound that process with appeal appeal after appeal, you never get to Election Day.
Or you die first. Mr. Andrews?
Ms. Slaughter, in response to your question to the chairman about the specialty health care decision, quote, wreaking havoc on the labor force, since the health care law was signed into law, the economy has added 400,000 jobs in the health care sector and has added 2.4 million private sector jobs since the health care law was signed into law. And we see no evidence that since August of 2011, which is when the specialty health care decision was issued, that there has been any slowdown in that number. So I think that contrary to the assertion that the decision has wreaked havoc on the health care labor market, the opposite has occurred. The jobs have been added.
Thank you very much. Mr. Bishop, do you expect the court system to see an increased workload from lawsuits? And I must say I agree with Mr. Miller, what he said, that the timeliness of this seems very strange since it's only been a week and a couple of days since Ohio received a trouncing on these very issues. I don't think very many people in America believe that they're going to blame the deficit on public employees, the firemen, the teachers, the police. That just doesn't hold any water. But would you explain your amendment a little bit better?
Without a deterrent to frivolous lawsuits, the legislation actually encouraged them to be filed, because the legislation requires that all challenges hearings on all challenges be completed prior to an election. So if an employer wants to delay an election, they can file frivolous challenge after frivolous challenge after frivolous challenge and stretch this out indefinitely if there is no sanction that would be interposed if such a procedure were taking place. So I think my amendment is absolutely essential to have some impact on limiting the number of challenges that would be put in place.
I certainly support it being made in order. Thank you, Mr. Chair.
Thank you, Mr. Chairman. I'd just like to thank the gentleman for coming today, and I have no questions.
Governor.
Thank you, Mr. Chairman. Before I get into the text of this bill, Mr. Andrews just said something that seems to contradict something that was said in this committee yesterday by our colleague, Mr. Sessions. You talked about the job growth that has occurred since March of 2010. yesterday in this committee, it was stated that the Affordable Health Care Act cost us 800,000 jobs. And we were told that CBO said that it cost us 800,000 jobs. And I went and I checked. CBO didn't say that, number one. And I'd like to ask unanimous consent to ensure in the record that an article from the New Republic entitled, "Sorry, the CBO did not say health care reform kills 800,000 jobs." I'd like to ensure in the record a page from Media Matters that says that GOP senators revive malicious distortion of CBO's health care calculations. And also factcheck.org did an analysis of a recent GOP New Hampshire debate, and they did basically fact checks on what they got right and what they got wrong, and this was one of the things they got wrong. I mean, there is this distortion. Thank you. There is a distortion that gets repeated over and over and over and over again, that this health care reform bill has cost us 800,000 jobs. Let me ask you again. I mean, have you heard that distortion, and have you found it to be as wrong as I've found it to be when I've
Well, I've certainly heard that assertion repeatedly, and it is a distortion. It's a distortion for two reasons. One is that the actual record from the Bureau of Labor Statistics since the health care law was signed in March of 2010 is the economy has added 2.4 million private sector jobs, 400,000 of which are in the health care sector. It's a distortion for a second reason, which the CBO points out. The CBO said was, because there would now be quality, affordable health care available to older workers who are not yet eligible for Medicare because they're not yet 65, that the CBO assumed that many of them would voluntarily leave the labor force because they could work part-time or not at all and still have affordable quality health insurance. So to claim that the CBO said that the health care bill would cost 800,000 jobs has been verified by the sources you talk about, in fact, a distortion.
Yeah, the Daily Show's Jon Stewart, I think, got it right. He mocked the Republicans when they concocted this distortion, saying that the Affordable Care Act is job killing in the sense that getting more sleep at night is awake killing. And I pointed out because lots of things are said here, but, sometimes if you don't correct the record, people begin to believe it's true. And I think on this case, the overwhelming evidence is that it's not true.
Gentleman, yield.
I'm happy to yield.
For one thing, I'm not an idiot, and I heard the gentleman, Mr. Andrews, say in the health care area there have been an addition of jobs. Is that correct?
Will the gentleman yield?
That is what you said.
I said two things. I said in the economy, we've added in the economy.
In the second statement that you gave, not the first statement.
In the economy, we've added 2.4 million private sector jobs, 400,000 of which have been in the health care sector. So there have been 2 million jobs not in health care added since the bill was signed in the private sector.
Well, you still have not provided any basis of a fact, because you would know that, as I was in reference, it was into a net. So did you net yours out?
Will the gentleman yield?
I would.
These are not my statistics. These are the Bureau of Labor statistics.
I'm asking if yours were net numbers.
Yes, they are net
So
statistics.
we've added how many jobs?
We have added a net
2.4.
2.4 million private sector jobs since the bill was signed.
Okay, so we've added 2.4 million jobs net.
Yes. Private sector. Now, we've lost some public sector jobs because people like the governor of Ohio have systematically laid off teachers and police officers and firefighters, which the voters of Ohio spoke to last week.
I
But in
would.
the private sector, it's been 2.4 million private sector jobs added.
I will promise to come prepared with my evidence quickly.
Right.
I appreciate the gentleman.
And again, I wanted to insert these clarifications to the record because they're not from the Democratic Congressional Campaign Committee's talking points or the DNC's talking points or the Democratic Senatorial Campaign's talking points. They're from sources that, by and large, I think both sides agree are objective. So I thank the Chairman for giving this opportunity. Now, on this bill that's before us, it seems that we're either attacking EPA or we're attacking working people and unions. We're doing a calculation here. There's been 49 actions attacking the NLRB in the 112th Congress. We've had, from hearings and bills introduced to threatening letters to the NLRB, this constant assault against this board that is designed basically to try to be a referee and make sure that union elections and worker complaints are treated fairly. And the bill before us, the way I look at it, it's just another in a series of bills that kind of falls into the category of what kind of wealthy special interests want. The fact of the matter is, people attack unions around here all the time, but we wouldn't have a middle class here if it weren't for some of the rights that unions had fought for and earned over the years. Everything from minimum wage to, health care benefits to worker protection. I go on and on and on about why workers have what they have right now, and yet everything we seem to be talking about in this Congress is finding ways to chip away at workers' rights, to lower the quality of living, to lower the standard of living for working people. We should be talking about trying to lift people up, not put people down, and the race shouldn't be to the bottom. We should be trying to improve conditions for middle-class workers. This bill, as I read it, mandates delay rather than minimizes undue delay in elections. I think it rather than discouraging frivolous litigation, which everybody here claims they want to do, this bill actually encourages it. It incentivizes amount of litigation for the sole purpose of gumming up the election process and stalling any vote. It's going to create a massive backlog in cases, including frivolous ones, on the taxpayer's dime, and the bill manipulates the procedure for deciding who is in a bargaining unit. So an employer would get an edge in preventing an election from ever being triggered by gerrymandering elections through stuffing the ballot boxes with voters who were never engaged by the organizing drive to begin with. I mean, is there anything I'm saying here? Am I missing something here? Is there anything that I'm saying that's not right? That's what the bill provides, Mr. Klein?
Well, thank you. Almost everything that you said is not right, in my judgment, which is why we're bringing the bill forward. What this bill does is, if the mandating delay language that you're talking about is the 35 days minimum that we're allowing workers to make sure they understand what their choices are. That 35 days, by the way, falls between the 31 days mean time that Mr. Miller was talking about and the 37 days median time. That's what it takes for workers to understand their choices.
Let me tell you my experience with kind of union efforts in my own congressional district. It's not easy to unionize in this country. And there are companies and there are factories that have been in existence for decades and decades that have never unionized, and when there have been attempts to try to unionize, actually they've treated their workers pretty well. The union effort never get off the ground. In areas where, quite frankly, workers haven't been treated so well, that's when workers kind of organize and say, look, we need to get together and fight for our rights. And in those cases, what I have seen is this overemphasis on doing everything, to protect employers at the expense of workers. The process is, this is not. You make it all sound like all the cards are with the workers in this country. I see it in a very different way. It's very hard to organize a union in the United States of America today. And I've seen the tactics that employers have used to try to destroy unions. The money that has come to the table, the threatening tactics, and I've seen NLRBs that sometimes have been indifferent to those things. Mr. Miller?
Well, even with those tactics, I think you see when you have a request for a pre-election hearing, whether it's this board or the Bush board, those hearings are granted in about 1 or 2% of the time, I think, because most of them, they're done for pro forma reasons, what have you. That's it. Where you do succeed in getting a hearing, again, the time goes out immediately. I'm not talking about consent cases, but challenge cases. But this is different. This one says the board has to consider them all. And this one says that it says that you you have to hold yourself to material that's relevant and material issues. But then it defines as any other issue that may have some impact on the election. You have to understand that this is a struggle for time, because time is the ability to influence the workers. And so you grind people down. You grind people down over time. They move, they quit, they get fired, what have you. And so, in effect, here with this happening at the pre-election stage, the election, you'll never get around to the election. Right. You'll never get around to the election. It won't be 100 days. It won't be the 500 days on average. It'll be multiples of that, because you've been given a license that unless you do something along the lines of Mr. Bishop's amendment, the doors are open for frivolous and dilatory tactics.
Well, let me ask you, would you be opposed to an open rule?
I have great confidence that the Rules Committee will bring forward a solid, structured rule that makes all germane amendments in order.
Boy, how times have changed. But anyway, thank you. I yield back my time.
Thank you, Mr. Chairman. I was on my way to agreeing with my friend from Massachusetts. He was laying out this case for why it is we're chipping away at workers' rights. And I'm thinking, I love workers. In fact, my voters are workers. And I'm thinking, why in the world would this, as a freshman in this House, would I have been a part of something that was chipping away at workers' rights?
Why?
And I wouldn't want to be a part of something like that. So I got a little outside the box and started reading the legislation, and I would encourage my colleagues who haven't to do the same. Mr. Klein, Chairman, tell me if I have gotten this wrong, because what I'm reading here in the committee report is that for decades, whether we're talking about Republican houses or Democratic houses, whether we're talking about Republican presidents or Democratic presidents, for decades, there has been a uniform standard at the NLRB for defending workers' rights against the overbearing business practices that my colleague references. And what I'm seeing here is that despite decades of bipartisan agreement on protecting workers, what we have here is a brand new standard out of nowhere by these unelected bureaucrats at the NLRB. Am I reading that properly?
That is essentially correct. This is a brand new standard. This is a change in the practices that have existed for decades. This will jam up the opportunity for employers to find legal representation and present their case down to 7 days. You should see what they have to be able to navigate in 7 days. And most of employers, certainly mid-sized and small employers, simply cannot do that. So this legislation helps employers present their case, gives them 14 days, and instead of attacking workers' rights, as we've heard here today, this protects workers' rights. It gives them, make sure they get a month, 35 days, to consider the pros and cons of whether they want to make one of the most important decisions in their lives. That's what we're doing here. And despite the lack of confidence that the relevant and material pre-election issues would be protective here, we certainly believe they will. This is not an opening for frivolous delay. This just puts into place the protections that have existed for decades.
Though that is just one example of a new overreach by the NLRB, as I think about what my colleague said about dozens and dozens and dozens of measures this House has brought forward to deal with the NLRB, I'm actually thinking about my friend from South Carolina, because as my recollection is, you all were growing jobs, you were adding workers in South Carolina, and the NLRB said no. Again, and you can correct me if I'm wrong, Mr. Chairman, overturning decade upon decade upon decade of precedent. I don't know how, when we talk about jobs bills, and my friend from Massachusetts is part of the conscience of this committee in making sure that we're focused on job bills. I talk to business leaders every day who tell me it is not worth doing business in the United States of America anymore. Not worth doing business. You know who can't leave? Capital can leave. Businesses can pick up and relocate overseas any day they want to. Who can't leave are the workers in my district. We're here. We're stuck here, and I want to keep businesses here. What I don't understand, and I don't come from a union area, to be fair. I come from the suburbs of metro Atlanta. Now, I would believe if I needed a plumber that I should call a union plumber, right? That folks tell me I'm going to get a better skill set, I'm going to get talent, I'm going to get integrity, and I'm going to go call that union plumber. What is confusing to me, though, if in my part of the world I think, golly, I want quality, so I'm going to go call the union guy, why is it, Mr. Chairman, that what we see is you've got to defend the rights of unions, that if folks are really providing more bang for the buck, if we're really getting a productivity increase, as I think I am when I go out to hire a plumber, why is there this sense that that we have to defend unions against corporations? Why is there the sense that Boeing hates unions and is moving? I understand that's not the case at all, but is locating new business. But why is there that sense? If unions provide more value, if unions provide more efficiency, why isn't there a rush for business leaders to embrace their unions instead of having this back and forth that we're talking about?
I suspect you're asking the wrong person at the table for that question. But as the gentleman knows, we have unionized workplaces all over the country in all kinds of industries, and many of them are very excellent, and they have very excellent relations between the employees, the union leadership, and the employers. But what we're talking about here is the organization, the formation of a union. And it is my position and the position of this legislation that the actions of the National Labor Relations Board this summer are unfair to employees and to employers. And so this bill takes steps and puts in statute protections for both employees and employers. And if employees then decide, after 35 days, for a month of discussions, that they indeed want to recognize this union and be a unionized workforce, then they can do it. And as has been the history, in almost 70% of the cases in these elections, that unions win and the workforce is unionized. So this is not anti-worker. This is to protect workers.
Well, you've said something very important right there, because I think that's right. I think everybody in this room shares a commitment to workers. And so when we have these discussions, I wonder, when are we talking about workers who are members of unions, and when are we talking about union executives? When are we talking about the union itself as an administrative unit as opposed to the union as a group of workers? I know in my experience in Georgia, our unionized plant building GM automobiles in Doraville closed. Our union plant building Ford automobiles in Hapeville closed. Our non-union plant building Kias started with one line, added a second line, and is now adding a third line. I don't much care who provides jobs for folks in my district. I need jobs. And I appreciate the effort of the chairman to make that easier as opposed to harder. Mr. Bishop, I'd like to ask you about your amendment. We were talking about the need for some of this legislation, some of this discussion we've been having in the House because of a seemingly new and overreaching NLRB board. I'm opposed to frivolous litigation. I happen to be an attorney, but anything we can do to streamline processes, I'm in favor of. Who is it that is the arbiter of what's frivolous and what's not?
What my amendment would suggest is that Chapter 11 of the Rules of Civil Procedure, the definition of frivolous proceedings that's contained in that chapter would be the guiding principle.
I saw the definition, which would be that of someone who practices in this field, but who decides whether or not that definition applies?
The board, the NLRB.
The board that we believe has overreached and we're trying to rein back in then has now the
Chapter 11 definition is pretty clear.
The definition is clear. It's the arbiter that I'm concerned. But I thought maybe it was going to go to an outside panel. Maybe it was going to go to a group of business leaders.
Can I also say that I understand the facts that you're implying. Let's say that you think that the regional director of the board, then the board itself made an incorrect judgment of what's frivolous. Remember, decisions of the National Labor Relations Board are appealable to the Court of Appeals. So ultimately, the U.S. Court of Appeals and possibly the U.S. Supreme Court would be the arbiter of what's a frivolous claim.
And given that in order to get all the information out there, we don't let the election take place until after these claims have been litigated, does that then delay the election until after the Court of Appeals makes a decision, as you have laid it out?
Well, no.
No.
Under the existing law, no. The election would take place. No. This bill changes the existing law and delays the election until the question of frivolity has been fully litigated. So it would delay the election, which is the point.
So we can, under the Bishop Amendment, I can file all of my grievances. I can have those grievances heard. If those grievances are found to be frivolous, I have an appeal that I can make, but the election will have already occurred before my appeal gets heard by the Supreme Court. Because my appeal to the appellate court, I'm sorry, does not shut down the election.
Not under the
talk about the
provisions of the bill. That's the underlying bill. Under existing law, you are correct. Under the provisions of the underlying bill, all of the appeals would be heard first before there's an election.
All of my district court, appellate court, that all gets found first.
Correct.
Fantastic. Well, that gives me great comfort. I sure wish there was a way, and I'm sure you looked for one, Mr. Bishop, to find folks other than the folks who were going to decide on the final case to answer that question of frivolity. But I absolutely appreciate your efforts to eliminate frivolity. If I can ever be your partner on that quest, I would love to do it.
I will eagerly anticipate a yes vote. Thank you very much.
Mr. Chairman, I yield back.
Mr. Chairman, I'd like to ask my good friend from Georgia, Mr. Woodall, about the plant that closed and the Kia plant that is providing workers with jobs. Which of the plants had the highest salaries for its workers?
Unquestionably, the ones that were uncompetitive and went out of business.
Your word, uncompetitive, chosen by employers to decide that they could pay people less. I happen to come from an area of the country, Broward County, Florida, where we have a living wage, and it's more than the minimum wage. What continues to discourage me in this body is as much the slamming unions up against the wall is ignoring the fact, and I echo the sentiments of my colleague, Mr. McGovern, that unions really created the middle class in this country. And if there were to be no unions, and I would assume in light of what has been transpiring here in Congress this year, again, echoing Mr. McGovern, we've had 8 measures defunding the National Labor Relations Board. We've had 10 attacking workers' rights to free and fair elections. We've had 18 measures are directed to the National Labor Relations Board with what they perceive as nuisance requests. And we've had 13 measures undermining the National Labor Relations Board's enforcement authority. Mr. Miller or Mr. Andrews, how do you perceive worker rights as it pertains to the National Labor Relations Act? What would workers do if there was no NLRB and if there was no National Labor Relations Act? Where would they have an opportunity to go, or what would they turn to protect their rights, in your opinion?
Well, I think essentially in the relations you would have a certain amount of anarchy because there would be no system which to contain the desire of workers to organize the workplace to achieve their goals. Their goals might be a higher salary, it might be better benefits, it might be a shorter work week, it might be weekends off, it might be a lot of different things, but those evolve over time in the workplace if the workplace changes. In today's situation, which you see articulated in many areas, is that there's been a conscious corporate decision to take more and more of the productivity of the workers, of the corporation, and rather than share them with workers, certainly since the early 70s, more and more of that's been sucked up through the corporation, either for shareholders or for the administration or for the top executives, And certainly, I would say in the last few years, workers have seen essentially no benefits, increase in benefits, offloading health care dramatically onto workers, so you would organize about that. And you see the upward sucking up of the benefits of productivity, record revenues, going to fewer and fewer people in terms of larger and larger bonuses in many industries, not just financial services, but in many industries. So where do you go to, how do you settle that dispute? In the streets? On the corporate grounds? Where do you settle that? You might look at something that's taking place out there with the MBA.
Yeah.
Okay, the workers said, we're out of here,
Yeah.
but they're still trying to get back to the National Labor Relations Board, and the employers, the owners, are trying to get back to the National Labor Relations Board to get this thing contained so they can see whether or not they can move. But if you decertify the union, you're out of there, and now what do you have?
Antitrust.
Maybe the players start an independent league. Maybe they cut a deal with the county arena that's lost all that revenue and says, we'd like to play for the next 60, we'll give you 60 dates for NBA basketball, or whatever they're going to call themselves, basketball.
Yeah.
So you can start to see the level of chaos that takes place in the economy. This board has been very good over the years to employers. It's been very good to workers. And it's balanced it back and forth, and it's worked out pretty well. You want to think about it in this day and age when people see the level of disparity, the level of greed, the level of selfishness that exists in the corporate world, and now they're aware of it, where would you like to contain that?
Yeah.
On the streets, like we're seeing when people get disenchanted, there's not a place to go where they think they can have their grievances heard?
Right. We hear the continuous arguments about the litigiousness of society, and I maintain that these kinds of actions that we persist in here are going to cause an awful lot of litigation. Mr. Chairman, I would close with the conclusion as offered by the minority in this committee, led by Mr. Miller and Mr. Kildee and Mr. Andrews and Ms. Woolsey. What they say is H.R. 3094 should be called the Election Prevention Act because its effect will be to delay and ultimately prevent union elections. This special interest bill is a misguided effort to divert the committee's attention away from creating jobs and focus on weakening laws that protect workers' rights. At a time when 25 million Americans are unemployed or underemployed, undermining workers' rights will further weaken an already struggling economy by resulting in depressed wages and reduced consumer demand. The primary reason that U.S. companies are reluctant to hire new employees. Committee Democrats are united in opposition to 3094 and will continue to fight for the rights of workers and middle-class families. And I join in that sentiment and say that we will rue the day that we continue down the path of disparity as it pertains to income and forcing situations where people make less money in the name of creating jobs is only going to create a worse economy, and I predict for you enormous crime. Thank you.
Hastings?
Yes, Mr.
You might yield. You raise a very important point because I appreciate the business community's campaign against the National Labor Relations Board, but I think if you really were to quiz them, this would not be their choice. You would have no board or an ineffective board where you couldn't solve these issues. But there's nothing corporations hate more than powerful workers or powerful shareholders. Shareholders essentially have no rights. Now they're working on making sure workers have no rights. They can't stand either one of them because each of them, workers and shareholders, have different ideas and contest, either whether it's just simply for a dividend or it's a governance of the corporation or the morality of the corporation. But if they were empowered, you would dread them. But the campaign is against taking the power away from shareholders, other than wait for your dividend or whatever,
Thank you, Mr. Chairman. Yeah, I've heard a lot of pontification today, and some of it's been entertaining, some of it's just been downright off-base, to say it nicely. We started with a conversation about the number of jobs created in the healthcare industry when the fact of the matter is the average American is aging significantly over the next several years. So we should look for an explosion in the healthcare industry. If we think that somehow the healthcare law has been a part of that process, then we are just kidding ourselves. I would say that when you take $500 billion out of the Medicare to fund this healthcare situation, we're going to find ourselves in a situation that's going to be a fiasco in years to come. So let's not kid ourselves where we're going with a new $2.6 trillion entitlement. I would say, however, that in 2009, with a 7.6% unemployment, today with a 9% unemployment, with 11 million workers out of a job in 2009, 13 million workers out of a job today. When you think about take into consideration the fact that we've lost more than 2 million net jobs lost in this country the last 3.5 years, it's interesting to have the whole conversation around jobs that have been created. So net versus non-net figures really don't matter if you just go to one source. There are 14 million Americans in 2011 not having a job, the 9% unemployment. Some figures say 13.6, some say 14 million. The question, have we added jobs to our economy or have we lost jobs in our economy? The question is answered by the statistics themselves. When we think about the impact of the NLRB on our jobs economy, anyone who thinks that America is now a kinder, gentler place to create a job is kidding themselves or haven't had the opportunity to create jobs in a very long time. I would say this, coming from that great state of South Carolina where some folks on the left don't believe that if you create a job in South Carolina, it's like actually adding jobs to the American jobs economy. It's really adding jobs in some alternate universe called the South. But I would say this, based on the comments of Mr. Solomon from the NLRB, as he quipped and joked in his April 22nd email, talking to one of his colleagues. He says, you go to Geneva, I'll get a job at Airbus. We've just screwed up the U.S. economy. Now we can tackle Europe. The fact of the matter is when the NLRB decides to become a part of the process and takes a side, we find ourselves in a position that erodes the American economy. It doesn't strengthen it. And we can go through emails on April the 28th from Miriam Imperial from the NLRB, or we can go back to May 12th, the NLRB Attorney Joseph Banzwisky, his email to an agency lawyer, Jennifer, and we see what is undergirding this entire conversation and move to take a look at the NLRB. It's an erosion of confidence based on their actions. And if we remember that we're not here serving the left or the right, but that we're here serving the average American worker, we would think about places that have strong union presence and good wages. And we would think about places like South Carolina that has a strong right-to-work presence. And we'd go to Nucor Steel, a non-union plant, where the average person on the production line has an income of over $80,000. We'd stop joking back and forth about what most Americans take very seriously is their ability to feed their family and why the federal government stands in the way of achieving that objective.
Will the gentleman yield?
Certainly.
While we've got these great minds in the room, I'd like to ask that very serious question, which is, I don't remember, Mr. Chairman, seeing these NLRB debates in the Hastert Congress. I don't remember seeing them in the Gingrich Congress, and I don't remember seeing them in years before. If NLRB were doing the same things this year and last year to protect workers' rights, to provide that, as Mr. Miller described it, a predictable place for folks to settle disagreements. If we had the NLRB of the late 90s and the early 2000s, would we be having these discussions today?
Mr. Woodall, we've seen in year after year, administration after administration, NLRB after NLRB, that the power, the majority shifts. And I distinctly remember when Chairman Miller was the chairman, he and his colleagues were exercised over the NLRB in the Bush administration. In fact, the committee took action. And he and I have had some discussions about that. It moves back and forth. It is my contention that we have got an extraordinary overreach, an extraordinarily activist NLRB that, as Mr. Scott, the gentleman from South Carolina, said, is actively participating on one side in this debate. And that's why this legislation, we think it's important to put in statute some specificity into what the NLRB can and cannot do that will result in fairness to workers and employers.
I thank the chairman. I thank the gentleman.
Yes, sir.
You know, Mr. Chairman, I spent a lot of time in my district meeting with businesses and, of course, meeting with workers as well. I was just on a panel at the Chamber of Commerce in Boulder County last week. This issue hasn't come up. I always ask businesses in my district, what do we need to do to get more jobs, to grow, to hire more people? Not once has this issue come up. Lots of great ideas, and yet here we are talking about a bill that I'm sure there's somebody somewhere that wants it, but none of the folks in my district or businesses that I've talked to or know have said this will create any jobs. I don't think the unions feel this will create jobs. I don't think the businesses feel this will create jobs. I'm just not sure why we're here. I mean, there's a major economic crisis facing our country. There's high unemployment. You know, I want to ask Mr. Miller and then Mr. Klein. Mr. Miller, are there any ideas we have to create jobs? I mean, is there any ideas or bills the President has or that we have that rather than discussing this, perhaps we could be discussing to create jobs?
Well, clearly, from the moment he took office, the President's offered efforts to create jobs. I mean, I think clearly his early recognition that we needed a modern healthcare system, a modern education system, a modern energy system, and a modern infrastructure system. All of those are tied to jobs. All of those are echoed time and again throughout the private sector as major stumbling blocks within the economy. And more recently, just a couple of months ago, he again offered up an attempt to create additional jobs in areas that are recognized to be helpful, whether it's a payroll tax deduction, whether it's expensing of equipment. Some of you may have been present today when Fred Smith from FedEx said the accelerated depreciation, the expensing, was absolutely imperative, not just for FedEx in terms because it's a heavy capital investment, but across the board in the economy. Those things. He thought what we finally voted on the hiring of veterans was very important. In fact, they're involved in a program. I think it's in Illinois to develop that along with the community colleges. So all of these address jobs. We can wait around and follow the austerity of Europe, which now has the rest of the world, on pins and needles in terms of what you do in the economy. But that's not coming forth from this committee. No, we've spent most of our time, and I think if there ever is an HHS appropriations bill, you will see all of the riders that are now being proposed on that bill to once again try to savage the National Labor Relations Board. Apparently, there's been a dozen or so that have been offered in that contest. So, yeah, there are alternatives that, in fact, how you can deal, this Congress can deal, this nation can deal with job creation.
Thank you. Those sound like some great ideas to create jobs. I know your committee and also some bills for school construction. And I'm just wondering, with I'll address this to the chair, Mr. Klein, I mean, is there any move to bring up any of these bills that would create jobs and get us out of this, or will we continue to kind of do nothing with these bills that I'm sure somebody wants? But I mean, I honestly talked to hundreds of businesses in my district. No one mentioned this. I mean, are there some larger job creation things we can perhaps see out of the committee?
I thank the gentleman. If I can address that, as we've said many, many times, this House of Representatives have passed now over 20 bills which we think directly address the economy and joblessness. Almost all of those now are sitting over in the Senate waiting for action over there. We have different ideas about what it takes to get America back to work. We believe the private sector's got to grow, the economy's got to grow. We believe there are way too many regulations, over 200, some 218, 19 regulations in the pipeline. So when you go and talk to your chamber and your businesses, as I do, most of them are struggling out there. They never heard of something called specialty. I'm not surprised they haven't heard of specialty, but they will if this becomes the law. If the NLRB's ruling takes place and they find out that in their workplace you can form micro unions, you can break up the whole store into 4 or 5 or 6 bargaining units, they'll have heard about it and they won't like it. And we just want to provide some certainty and some confidence to the private sector so they can get back to work.
Great. Mr. Andrews?
Well, 2 points to my friend from Colorado. The first is that the so-called specialty case is really about packing people into a bargaining unit at the whim of the employer that makes it virtually impossible for the union to win an election. There's been a fair standard for 5 or 6 decades where if you disagree with the content of the bargaining unit, the burden of proof is on the party who disagrees with the structure of the bargaining unit. This bill radically and, in my view, unwisely shifts that burden to the union in all respects. The second point that I would make to my friend from Colorado, the chairman, as he usually does, gave a very thoughtful exposition of the Republican position, which is that the country has a jobs crisis, and the answer is to get rid of job-killing regulations. That's their new mantra. It's interesting, though, if you look at statistics kept by the Bureau of Labor Statistics in 2010, the Labor Department asked employers who in fact had laid people off in 2010, why did you do it? What was the reason behind the layoffs? 0.2% of the employers said the problem was regulations. That was, 0.2% was government regulations. 36.5% said it was a lack of customers, a lack of demand. When you read surveys of businesses across the country, hugely higher numbers of businesses say the problem is a lack of customers, lack of demand. How do you create demand? Well, why don't we hire construction workers to rebuild roads and bridges and schools and libraries, which the President's proposed, but the majority won't take up? Why don't we cut taxes for small businesses who hire people, which the President has proposed, but the majority won't take up? Why don't we make certain that we don't have a $1,500 a year tax increase on every person who earns wages in this country on January 1st? Why don't we avoid that, which the President has proposed and the majority won't take up? Why don't we go to towns that have had to lay off teachers and police officers and firefighters and give them some help to keep those individuals on the payroll doing their jobs so they can buy products in the stores and eat in the restaurants, which the President has proposed and the majority won't take up? So if you listen to the real job creators, they will tell you that the main reason they're either not creating jobs or laying people off is not government regulations. 0.2% say that. 0.2%.
Well, the gentleman,
36.5%, it's his time, 36.5% say it's not enough demand. So why don't we address the demand problem instead of this continuing assault on the National Labor Relations Board and America's workers?
Thank you. There's some excellent ideas that I hope the chairman considers. Some of those ideas that are under their area of jurisdiction, I'll be happy to yield to my friend for a moment.
Ms. Andrews, you're really good. I like to listen to you talk. This is
I'd
awesome.
like to listen to you too, Mr. Scott.
Thank you, sir. Can you cite that source again, please?
It's the Bureau of Labor Statistics.
Because the folks who actually create jobs, which is this group called NFIB, according to their most recent survey, that 41% of the small businesses in America cite the fact that the #1 cause for challenges in creating jobs happens to be government regulations.
The gentleman would yield me.
Yeah, and just to be clear, I want to be sure the NFIB does not create jobs. They're a lobbying organization. Their members might create jobs. They might just have a few lobbyists they employ and perhaps a few researchers.
Thank you for the correction. I think it's very important for us to recognize that the NFIB probably does more in facilitating the opportunity for job creation through their members than, I don't know, the federal government.
No, I don't
appreciate
know if
that.
many of their members are necessarily aware of their what they're doing.
I'm sure
I'll yield to the gentleman from New Jersey.
If I could, let me just say that we have a vote going on downstairs, and this is a fascinating debate that's taking place. All of these issues will be able to be discussed.
I'll yield to the gentleman from New Jersey.
One quick.
If I might finish.
Mr. Chair, of course. I'll yield to the chair, of course.
I'd like to say again, we have a vote on the floor. This committee has a job to do. The job to do is to report out a special rule. And I assure you there will be an opportunity for a free-flowing debate on this issue on the House floor. And I hope very much that we can move to the work of the committee as soon as possible. I thank my friend for yielding.
Thank you, Mr. Chair.
Claim your time.
I want to give Mr. Andrews a brief moment, and then I'll close.
I'll be very brief. I'm sure my friend from South Carolina knows that the small business majority
Yes, sir.
conducted a survey of over 1,200 small businesses. 13% said government regulations was the main reason for their lack of growth, and 50% said it was lack of demand. I would yield back.
And thank you. I just want to close. And I think that this race to the bottom is very dangerous. I think there's no one that disputes that you can strip away labor safety requirements and create jobs, unsafe jobs. You can get rid of the minimum wage and you can create jobs, $2 an hour jobs. I mean, there's not a dispute about that, but I think this race to the bottom is not good for the country, it's not good for working families, it's not good for job creation, and I'll yield back the balance of my time.
Mr. Webster. Gentlemen, thank you all very much for being here.
Thank you, Mr.
We
Chairman.
appreciate it. And that'll end the hearing, and we will proceed with consideration of the rule. The chair will be in receipt of a motion.
Mr. Chairman, I move the committee report structure rule for consideration of H.R. 3094, the Workforce Democracy and Fairness Act. The rule provides 1 hour of general debate, equally divided and controlled by the chair and ranking and minority member on the Committee on Education and the Workforce.
Could we have, we're trying to report out the rule here. If the thoughtful staff members who are engaging in conversation could suspend while Mr. Sessions offers his motion, we'd appreciate it.
Thank you, Mr. Chairman. The rule waives all points of order against consideration of the bill. The rule provides that the amendment in the nature of substitute recommended by the Committee on Education and the Workforce now permitted in the bill shall be considered as original text for the purpose of the amendment and shall be considered as read. The rule waives all points of order against the committee amendment in the nature of a substitute. The rule makes in order only those amendments printed in the Rules Committee report. Each such amendment may be offered only in the order printed in the report, may be offered only by a member designated in the report, shall be considered as read, shall be debatable for the time specified in the report, equally divided and controlled by the proponent and opponent, shall not be subject to amendment, and shall not be subject to a demand for the division of the question. Rule waives all points of order against the amendments printed in the report. Finally, the rule provides one motion to recommit with or without instruction.
You've heard the motion of the gentleman from Dallas. Let me just explain that we had 7 amendments that were submitted to us. 2 were withdrawn, 4 of which were germane, and they are all from Democrats. We make all of those amendments in order. I would like to say that, that speaking in behalf of the staff members of the Rules Committee, we would be very appreciative if members would submit amendments in a timely fashion. We had amendments, an amendment deadline that was announced for 10 a.m. this morning, and we announced that exactly 1 week ago. A week ago today, that deadline was announced, and we received amendments up until just a little before 12:45 today, and you know, unlike the way it was done before, we're trying to accommodate Democrats and Republicans and not cut people off, but I think that it would be very important, out of respect to these staff members, to let people know that we do want to try our doggonedest to stay within a reasonable amount of time from the deadline that has been announced. So with that, are there any amendments? Ms. Slaughter.
I have one following the mood of giving everybody an opportunity to be heard. I move the committee report an open rule for consideration of H.R. 3494 so that all members have the opportunity to offer amendments to this bill.
For the motion of the gentlewoman, the vote occurs in the slaughter. Remember, those in favor will say aye. Those opposed, no. Pay the chair. The noes have it. The noes have it. Clerk, call the roll.
Mr. Sessions. No. Mr. Sessions, no. Ms. Fox. No. Ms. Fox, no. Mr. Bishop. Mr. Bishop, no. Mr. Woodall. Mr. Woodall, no. Mr. Nugent. Mr. Scott. No. Mr. Scott, no. Mr. Webster. No. Mr. Webster, no. Ms. Slaughter. Aye. Ms. Slaughter, aye. Mr. McGovern. Aye. Mr. McGovern, aye. Mr. Hastings. Mr. Hastings, aye. Mr. Polis. Aye. Mr. Polis, aye. Mr. Chairman.
No.
Mr. Chairman, no.
Clerk, report the total.
4 yeas, 7 nays.
And the amendment is not agreed to. Are there further amendments? If not, the vote occurs in the motion of the gentleman from Dallas. Those in favor will say aye. Those opposed, no. Pay the chair. The ayes have it. The ayes have it. The motion is agreed to, and this is to be managed by Ms. Fox, and for the majority, and Mr. Polis. So thank you all very much. We've had our last meeting for the week. I hope everyone, believe it or not, we have. So hope everyone has a nice Thanksgiving, and without objection, the committee stands adjourned.